People versus ex-rel Neville versus Toulon.
Good afternoon. May it please the court, Timothy Reservato of the Mental Hygiene Legal Service for the appellant Ralph S. I'd like to reserve 2 minutes for rebuttal time.
Yes, sir.
Thank you. Your Honors, this appeal challenges a provision of the mental hygiene law, 1011D4, as unconstitutional on its face and as applied to appellant. The provision concerns revocation of strict and intensive supervision and treatment, SIST. It allows for a finding of probable cause and pre-hearing confinement on an entirely ex parte process based only on the state's petition and papers, where the result is that an individual is removed from the community and detained in jail indefinitely pending a hearing.
Why
without-
isn't the liberty interest diminished because of the prior cyst finding of mental abnormality by a jury?
Well, that's a good question, Your Honor. That's essentially what the appellate division below held, was that because there was this finding of mental abnormality, that someone who's on cyst isn't entitled to the full due process protections. But that's not the case. An individual on cyst has been found appropriate to be on cyst by a judicial finding, and that means that the state has failed to prove that they have that they required confinement. So what this
Well,
did...
that's not necessarily true. It's a discretionary finding that they could be placed on cyst, but initially the finding is that they have a mental abnormality, which indicates dangerousness.
Respectfully, Your Honor, it's not discretionary. The state could agree to cyst, but otherwise, if the state doesn't agree to cyst, the only way someone would get on cyst is if they were found not to be so dangerous as to require confinement.
So is your argument that having been placed on cyst, as a matter of law, they were deemed at that point to no longer have a dangerous mental abnormality?
Dangerous is the word there. In fact, when someone's found appropriate for cyst, the question is whether the person is, in the statute, a dangerous sex offender who requires confinement.
But my question's a little different, because there has been a prior adjudication, and I'm asking you whether the effect of the cyst order somehow vacates that prior adjudication with respect to the finding that was made at the initial commitment.
Not at all. Every person who's on cyst has been found to have a mental abnormality. But they've also been given a state-created liberty interest in remaining on cyst, and they have a legitimate expectation that they will not be removed from cyst and put in jail without reasonable due process accommodations.
Can I ask you, are you making, right here, are you making only a procedural due process argument or also a substantive due process argument?
This is a procedural due process argument.
Okay.
What happens is, the situation is most similar to parole. Parolees have a liberty interest in remaining on parole, just like individuals on cyst have a liberty interest in remaining on cyst. Parolees, though, have both a right to a preliminary parole revocation hearing on the need for pre-hearing detention, which was required by the U.S. Supreme Court in Morrissey v. Brewer, and they have a enforceable limit of 30 days of pre-hearing detention. Now, both of those procedural protections are expressly denied to individuals pursuant to 1011D4.
Does
And
it
I-
matter that the parole, you're talking about a criminal process and going into a prison versus a civil confinement?
It does matter, because here, this is purely civil. So even if someone's on parole, they still owe a criminal sentence. This is a purely civil matter where someone is being put into jail.
So your argument, he should be entitled to greater protections?
Absolutely, because this is a purely civil process.
And is your argument that there's no confinement at all allowed on an ex parte finding of probable cause, or only if it runs more than 30 days?
I would say there should be no confinement on an ex parte finding. You have to give the person due process opportunity to be
So
heard.
zero days, you can't confine at all, your view is, before
Well,
there is?
initially, the individuals are taken into confinement for 5 days, and that's before the state has to bring their petition and the ex parte finding is found.
So the first 5 days are permissible in your view under due process, but then there has to be an opportunity to be heard, and if that's done in the 30 days, that's still not sufficient?
No, it's not, because there needs to be the preliminary opportunity to be heard before the time begins to run. Now, the appellate division largely found that this was permissible because of other procedural safeguards, but those safeguards are largely illusory. For example, the fact that mental hygiene legal service is alerted when they are taken into custody for the initial 5 days doesn't really help us prevent any unjust deprivation, because we're not allowed to argue on his behalf on the probable cause finding. So it doesn't really help anything. And another supposed protection is the 30 days that was mentioned. But
Could you move to set aside the ex parte order?
no, in fact, there is no way to challenge it. And the statute even says if it goes beyond 30 days, it specifically says any failure to commence the hearing within the time period specified shall not result in dismissal of the petition.
So the court can't, with respect to, when you say ex parte order, you're referring to an order of the court?
Yes, the initial
Can a
probable
court,
cause finding.
upon an application, withdraw its own order?
It's not permitted by the statute as it's written, which is why it's unconstitutional on its face.
Well, I don't know how it's not permitted. It might be difficult to make the application if you don't have access to the paperwork, but I don't think it's not permitted.
Well, for specifically, if it goes beyond 30 days and we were to argue that the duration has become excessive, it specifically says that it shall not be dismissed, and there shall...
Yes, but that doesn't foreclose an application for an immediate hearing.
Well, the hearing...
Would that not help to protect the individual's rights?
Well, at that juncture, the damage has already been done if it's gone over the 30 days. The individual has been confined at that point without due process on a purely ex parte situation. And in fact,
Can you cite an example of an adversarial probable cause finding process that is analogous to what it is you're proposing be done here? Because I think in general, most people think that these probable cause determinations are not made with an adversarial process attached to them.
well, the best example, like, as I mentioned, is parole. Someone who's on parole and they are alleged to have violated parole, they get a preliminary hearing on the need for pre-hearing detention until such time as they can have their final parole revocation hearing. And at that hearing, they get to present evidence, they get to confront witnesses. That's exactly the situation that we would ask for here.
And is the fact that those hearings are essentially criminal in nature, you know, the person's facing additional incarceration and criminal, not an important distinction?
It is an important distinction because this is purely civil. Individuals on CIST have more rights. They should not be put in jail for longer periods of time, especially because this is a civil proceeding.
If you know, do you have a sense of how often the hearing is held more than 30 days after the probable cause determination?
Yes, in practice, it is virtually never held within the 30 days. It is almost always much longer, as it was in this case. This case, it was 5 months.
So I just want to be clear that I understand the procedural setup of this. You're asking for a probable cause hearing early on,
Yes.
at which the issue would be whether there was probable cause to believe that the person had violated the terms of CIST.
No.
Is that, no?
Because this, unlike parole, where the issue at a parole revocation hearing is whether someone has violated the parole conditions, on CIST, the only issue is the same as at the initial disposition. It's whether the person has become unable to govern their sex offenses. So you could have a situation,
So it's the same thing that you would be asking for in the 30-day hearing, same standard?
yes.
Okay.
You could have a situation where someone has actually violated a CIST condition, but because there are hundreds of CIST conditions, at least sometimes over 100, many courts have held that violation of certain CIST conditions is not, as a matter of law, sufficient to justify confining someone, because there's a lot of technical violations.
On your as-applied challenge, which I take to be to the nature of the CIS violation here, are you arguing that it violates due process to rely on that condition, or it violates the statute?
Both, because,
And why does it violate due process?
well, because we didn't get an opportunity to raise the argument
Right,
initially.
but if you had been given an opportunity to raise the issue, so the procedural aspect with regard to the timing is taken out of the picture. Are you arguing that as a matter of procedural due process, that you can't rely on the condition here?
That would be just as a matter of law of what would constitute the sufficient evidence to
So the-
justify confinement.
Okay, and do you, is your view that as a matter of what the statute allows, that the alcohol use is permissible? If there's a proof, if there's proof provided that it's causally related to the inability to control impulses?
There was a Fourth Department case that gave guidance on this, and it was State v. Georgian. And that case held that, quote, "The statutes and case law do not permit the state to confine any sex offender who drinks a beer while on cyst."
Right, I'm asking, is that your view, that the statute does not permit confinement for alcohol use, even if there is proof that alcohol use makes it not possible for the individual to control their sexual impulses?
No, there may be an argument, but in most cases, that's not going to be the case.
So it's a matter of proof?
Right, and we would need an opportunity to challenge it. And in fact, in this case, when he eventually did get his final cyst hearing, he was released and returned to cyst because the judge properly found that the alleged violation didn't show that he had become unable to govern his sex offending conduct because he wasn't related to sex offending behavior. So you can't say that we would have definitely failed on that argument, and perhaps he could have avoided 5 months in jail if we could have at least...
Can I just clarify on that original ex parte application? Is the court simply deciding whether or not there's a basis for the allegation that there is a violation of cyst, as opposed to whether or not that shows that indeed he
No.
can't control his impulses and he needs to be confined?
They're, at the initial probable cause determination, they're determining whether there's probable cause that the individual has become unable to govern their sex offending and requires confinement. I see my time is up. Thank you.
Thank you.
Good afternoon, Your Honors. May it please the Court. Kwame Akoso for the Office of Mental Health. This Court should affirm the appellate division because an ex parte probable cause determination in cyst revocation proceedings does not violate due process on its face or is applied to the appellant.
Can I ask you if you agree with the characterization that the hearings are virtually always held after 30 days, to the extent you know?
Oh, Your Honor, it is our understanding the vast majority of cases, the court will put on the hearing in less than 30 days as required
So
by
you
the
have
statute.
the exact opposite view of your
I don't have the
adversary.
exact, what I'm saying is the court will schedule the hearing, but then the parties will take an
I
action
see.
subsequent to
Okay.
delay the hearing. And so in the vast majority of cases, based on my conversation with trial counsel, what occurs is that there's a request for an adjournment, which
That
will happen in this
here,
case.
didn't it?
Sorry?
Didn't that happen here?
That's what happened here, Your Honor. There's a request for an adjournment. The hearing was scheduled 22 days after the state filed its petition for confinement, and there was a finding of probable cause. And then there was an adjournment, and then to obtain an expert evaluation. And that expert evaluation was not brought until the middle of March, and then a few days later, the COVID-19 pandemic caused.
And so I take your view, but tell me if I'm wrong, is that the 30 days in the statute is totally hortatory, basically. It has no, it can't be enforced.
No, Your Honor, we would seriously dispute that. The statute.
So what are the consequences for going beyond 30 days?
Well, the consequences for going, Your Honor, we would dispute the idea that there needs to be a consequence in order for there to be a right to a
Okay.
hearing within 30 days.
But if it's not adhered to,
Right.
what, if any, consequences are there permitted under your reading of the statute?
My understanding of the statute is the remedies available in a circumstance where a hearing is not provided in 30 days. At a minimum, the appellant or the respondent needs to make an application to have their hearing within 30 days, or a motion. And if the court denies that, they can seek mandamus relief, or in this case, habeas relief. But at a minimum, there needs to be some attempt to have the hearing within 30 days.
So if they do that, and they try to get relief via mandamus or habeas, set to the side whether, that's a reasonable burden, what in the statute authorizes the court to provide the relief? It seems to me that probably either the 30 days is a requirement that has to be complied with, or it's essentially a suggestion. So I'm trying to understand which of the two you think it is.
I think it's a requirement that must be complied with. It is a right conferred to every respondent in cyst revocation proceedings. The statute is very clear that the hearing has to be held within 30 days. That means it can be held any time before the 30-day mark.
And if it's not,
And if it's not, the proper recourse, just to clarify, the statute does not say that the provision is toothless. What it says is that there are certain remedies that are not available
Right.
in circumstances where the 30
so what
days.
remedy is
The
available?
remedy is to hold the hearing. In a situation where the hearing is not held, the remedy is to hold the hearing. And if that fails, the mandamus relief or other sorts of forms of relief.
On average, how long does it take to get a competing psychiatrist's evaluation report?
Your Honor, as I stand here today, I don't have information about the sort of MHLS's time to get a competing psychiatric evaluation, but the statute is built under the assumption that the psychiatric evaluation would be obtained in the short period of time between the state's petition for confinement and the final revocation hearing. And this legislature designed it this way for a very practical reason, is because the probable cause determination, as my colleague just mentioned, has to be made with expert evaluators. It's a question that goes to their psychiatric state of mind, whether or not they have an inability to control their sex offense conduct. And so that requires expert testimony. And the state's petition contains an evaluation that was conducted in a short 5-day period. And in that period, the stakes are quite high for the state. What happens is that the individual is taken into custody, and the state has to conduct a mental health evaluation in that short period, file the petition for confinement, and then the court has to look at those papers and make a determination. And that's a reasonable system that the legislature put together because.
Well, so the hardest thing over here, the hardest thing I think for you is Morrissey, so maybe you can address that.
Well, Your Honor, I think there are important distinctions here between parole. I think at the outset, the CIST procedures are imposed by a court with the opportunity, notice an opportunity to be heard with the right of counsel, and they're signed before the court. And the court also plays a role in
So is
overseeing
the sentence
CIST.
of conviction in a criminal case.
Yes, Your Honor, but the CIST conditions, and like the special conditions of parole, are imposed by a court rather than by a parole board or a parole officer. So that's an important distinction on the front end in terms of due process. And then going forward, if there needs to be a modification in the CIST conditions, those also have to be done by a court. And the court plays an important role in monitoring the CIST performance. They get quarterly reports from the Office of Mental Health, and all parties get this information about how the progress is going. And then in that first 5-day period, as I was just outlining, the court plays an important role in making a probable cause determination.
What is the burden of allowing MHLS to appear?
Well, Your Honor, I think at the outset, the probable cause determination is not a particularly high bar. So the question under Matthews, right, is whether or not the additional procedure would be useful in correcting erroneous deprivations of liberty. And it's just not clear that the adversarial process here would do that because it is not a particularly high bar to establish probable cause. The judges are well equipped to make these determinations on their own without a battle of the experts or the weighing of witness credibility. These things are not essential to probable cause determinations. And so what would happen is that if there needs to be a hearing, it would ultimately delay that predetermination period of detention.
Counsel, your adversary argues that the due process protections that are currently in place in the regime are illusory, I think is the word that he used, a proposition I'm sure you disagree with. But why is it that you feel that these provisions are sufficient for minimum due process concerns, especially where there's no opportunity for input from the person who's looking at a deprivation of liberty?
Well, at the outset, as this panel has already identified, is that an individual on CIS has already been subject to a mental abnormality finding by a trial, and that goes to their dangerousness. And so we're talking about individuals here who are not just your typical recidivists. We're talking about people here who have a serious difficulty controlling their sex offense conduct. So there's an important need for the state to be able to act quickly and detain the individual and obtain a probable cause determination. So
you're saying the state's interest is enhanced by the fact that this person has already been adjudicated a dangerous sex offender?
That's correct, Your Honor. I think the state has an important, in the balancing test, the state's interest here is quite important because of the nature of the mental abnormality. And then I said, as I laid out, there are these other procedural safeguards. They are not illusory. At the outset, the court has to impose the CIS conditions. And then if there's a CIS violation and there's someone who's taken into custody, MHLS is immediately notified. That gives them time to get their expert in order. And then there's a mental health evaluation, and in this case, MHLS counsel was present to observe the mental health evaluation. And then in that 5-day period, the state has to file a petition for confinement, and if it fails to do so, if it fails to get everything together in that first 5 days, the individual is returned to SIST automatically. And that is an important procedural safeguard right there. So if the state is able to get an expert to agree with the parole officer's allegations.
Does that happen very often in real life? Does the person get brought in and then the attorney general or whoever's required to finish the paperwork decides not to submit it?
Well, Your Honor, in this case, in fact, there were some violations of SIST that did not result in a petition for confinement. I believe there was an incident report for testing of cannabis in February of 2019 that didn't result in a petition for confinement. So it's not just that the expert rubber stamps whatever is alleged. The expert has to conduct a thorough evaluation and make a determination about whether or not this particular violation is reason to believe that this person is a dangerous sex offender requiring confinement.
Will you come back to your question, your answer to the Chief Judge's question about Morrissey? I'm not sure I fully understand your argument that it's distinguishable.
Well, the distinction here is the safety issue first. There are a few issues, but the first is the safety one, is that individuals who are on SIS have already been adjudicated at trial to have a serious difficulty controlling their sex offense conduct.
Well, there are plenty of people in prison who are recidivists, who have a great difficulty, maybe inability to control their robberies or their murders or, other things. These people are different in that respect in that they're sex offenders, but there are plenty of people who are in the regular parole system who can't control their offending behavior.
Right. Certainly, Your Honor, but there has not been a process to adjudicate whether or not they have that condition.
Well, what if we were to say folks who have been found guilty of a violent crime, perhaps are more akin to the individuals here? Is it because the determination here is targeted only at dangerousness and not simply at whether you committed an act that might evince dangerousness?
It is about dangerousness in one particular aspect. It's volitional impairment, the inability or the lack of ability to control one's behavior. That's the key distinction here. And so that finding exists for individuals who are on SIS.
You might say it exists for persistent felony offenders too, and there's a designation for that and rules around that, and those people are released on parole.
You're correct, Your Honor, but what I would just say is that the primary purpose behind SIST and the mental abnormality trial is to treat individuals who have this particular type of mental abnormality that goes to volitional impairment, and it's demonstrated through expert testimony, and there's plenty of procedural safeguards in these proceedings about the various conditions that may qualify for mental abnormality.
Let me ask you a practical question. When there's a SIST violation, do you pick the person up and then start the paperwork, or do you start the paperwork first and then pick the person up?
Your Honor, I think the paperwork will probably start after the individual is picked up, but there's been ongoing monitoring of the individual. So in the psychiatric evaluator in this case, in fact, completed an annual evaluation in November of 2019, just a month before the person was picked up. So there was some work that was done beforehand. So I guess it's not accurate to say that there's nothing done beforehand, but the point is that there's been evaluations and monitoring throughout the SIS process, and all that information is taken into account by the mental health evaluator.
And it's up to you when to pick the person up. You don't have to pick the person up as soon as there's a violation.
No, Your Honor. There has to be, what happened here was the parole officer concluded that this was a very serious violation.
No, I'm just sort of going back to your idea that you have only 5 days in which to do all the things you need to do to meet this very low bar, that you actually could do those things in advance of picking the person up, and if the bar is that low, it may not be that much that you have to do to demonstrate probable cause.
Well, certainly, if the state needs to act quickly if there's been a SIS violation. In this case, the SIS violations occurred days before the person was taken into custody, so it wouldn't be possible for the state to anticipate the SIS violation and then prepare the petition. So in most cases, these are serious safety concerns.
So in explaining why, in your view, the opportunity to appear is not something that adds a lot under the Matthews calculus. I think you said that it's a low bar, the probable cause determination. Setting that to the side, is there some practical reason why allowing an appearance, if the determination is still one of probable cause, not the finding itself, would be difficult?
Yes, Your Honor. I think it also goes to the potential for delay here. And so the important thing is that there be a final revocation hearing within 30 days. And so the legislature set up a system where there could be an expedited process so that we can ensure to have that 30-day hearing. And so if we add more process, it introduces more practical limitations for having that 30
But
days.
specifically, I take it what would be involved is notifying MHLS, which I think is already done, right, of the time and place of the probable cause determination, and actually letting them stand up and presumably consult with their client in advance of doing so. Why would that step specifically introduce a lot of, logistical challenges?
Because under the current framework, it's done on the papers, so there is no proceeding or hearing. And so what happens is that the state provides the expert evaluation, and the court has to promptly make a determination. In this case, the determination was made the day it was filed. If there had to be a proceeding, the parties would all have to get their experts together and appear before the judge.
So
And
there's not an in-person
No.
hearing prior to the probable cause determination, it's just done
it's on the papers, Your Honor.
on the ex parte papers?
That's right.
And could you allow the MHLS attorney, if they chose to do so, to submit papers in response?
Well, Your Honor, what that would entail is that they would need to have additional time after the state's 5 days in order to get their expert evaluation and produce their papers to rebut the allegations in the petition for confinement. So that would ultimately just delay
But it
the,
sounds like you're not concerned when, as regards the 30-day hearing, they ask for an extension of time, and that kicks it way beyond the 30 days. You're perfectly willing to tolerate that delay, and I don't think you disputed what counsel said, that in fact, these hearings usually occur after the 30 days. So I'm wondering why you don't seem to care very much if they ask for an extension to get their expert in line for the 30-day hearing, but you have a problem if they want, say, 5 days to put in some papers on probable cause, because it might cause a little bit more delay.
well, Your Honor, the standard with Matthews here is the question of whether or not this procedure is going to be useful in limiting erroneous deprivations of liberty. So it's not enough just to say, well, what about this liberty protecting procedure? What about this procedure? The question is whether or not the procedures on the whole provide enough due process protections. And the procedures do provide due process protections because the hearing has to be held in less than 30 days. And so if the parties are ready to proceed to a preliminary hearing, I see my time is up.
Go ahead.
If the parties are ready to proceed to a preliminary hearing and they have their experts, they have their witnesses, then due process would be better served for the parties just to proceed to the final hearing. There's no limit, there's no provision in the statute that would prohibit the court from having a final revocation hearing in far less than 30 days. In fact, in this case, the final hearing was scheduled for 22 days. If the parties are truly ready to proceed to have experts and in-person argument, an adversarial process, they might as well proceed to the main thing rather than have a dress rehearsal where the same question presented exists but for the probable cause standard.
Chief, may I ask one additional question? On the facial challenge with respect to duration, do you agree that if we were to conclude that the regime as it's set up in the statute, which allows for the people to present their papers and get a probable cause determination without any opportunity to file something else within those 5 days, doesn't provide sufficient procedural safeguards, would the facial challenge then succeed, or would there need to be is there some other circumstance in which an as-applied challenge would fail and therefore the facial challenge would still fail, if you follow me? In other words, would you agree that in that circumstance it would be unconstitutional in all its applications?
No, Your Honor, we wouldn't agree that in that context, if this court were to think that the 5-day period doesn't provide enough procedural safeguards, that it's unconstitutional in all circumstances, because the statute permits for the hearings to be held expeditiously if the parties are ready to proceed and have the hearing.
So the potential that you could have a hearing, I'm not sure if one's ever been done, and maybe you know, but you could have a full hearing within 5 days, would, in your view, obviate the facial challenge? Is that your view?
With respect to the issue of duration and
Yeah.
necessary
Yes.
procedural safeguards for the 30 days or the 5 or whatever period we're talking about here, the possibility that this hearing can be held in a reasonable amount of time under the current statutory provisions, and that individuals, if they have a right to the hearing in less than 30 days, and if they want that hearing earlier, they can move the court and request it, And it's their right under the statute, and if they're ready to proceed in that and have that revocation hearing, they may do so. So I would say the statute provides the necessary safeguards in some respects, and if there are situations, there may be situations where someone is detained for long periods of time and the reasons are chargeable to the state, or there's some other reason like that, that would be a basis as applied challenge, perhaps, to say that these reasons may suggest that the statute is unconstitutional as applied to you.
What might be the outer limit in when the hearing could be held beyond the 30 days?
Well, Your Honor, when courts have generally not drawn bright lines when it comes to this sort of thing, but really generally it's a totality of the circumstance test. You take into account the length of the duration, whether or not there's been prejudice, and in particular the reasons for the delay. And I just want to stress, Your Honors, that when there was an opportunity in Supreme Court for MHLS to put in reasons for why there was delay in these proceedings, why they were having difficulty having getting an expert, they implored that the court not explore the reasons for the delay. And that means that the durational as applied challenge has not been preserved for review in this court, and I would just encourage this court, I would just argue that this court cannot address it. But in terms of the reasons for the delay, MHLS sought an adjournment from January 15 to February, and then the expert evaluation was not brought until March. None of the delays here were chargeable to the state. So under the circumstances here, the state did not violate due process.
I was more interested in what might be the outer limit, not when they're seeking an adjournment. I understand your position fully. When they're seeking the adjournment, the delay is falling on their shoulders. When some of the delay may be caused by your office.
Well, Your Honor, again, I would say that it is a totality of the circumstances test. Every situation is different, so the question is how much is it chargeable to our office, the delays, how much are chargeable to MHLS, and so the outer limit here, we would say at the outset, is 30 days, and then everything else has to be thought through with whether or not who was responsible for the subsequent delay, who bear more of a responsibility under the circumstances.
Thank you.
If there are no further questions, we ask that you affirm.
Your Honors, I'd just like to say, with respect to the Matthews factors, yes, the state does have an interest in supervising individuals who are on cyst, but individuals on cyst also have a greater state-created liberty interest and a legitimate expectation that they won't be removed from staying on cyst without at least having due process of law. And we have no burden at the initial probable cause hearing. The burden is entirely on the state, so we don't have to produce an expert. We can challenge their evidence and see if they've made sufficient arguments and if they've
And so as a
offered
practical
competent-
matter, how quickly could you do that if you were asked, if you had the opportunity?
We could do it immediately. I would think a fair compromise would be if you have the probable cause hearing within 3 days of the petition. That's if you look at other provisions of the Article 10 statute, like 1006H, that's the time limit for when someone is released and prior to an initial MA determination. So I think that would be enough time to have a hearing, and then if you enforce the 30-day time limit after that, I think it would bring this statute into constitutionality. But as it stands now, you have 1011D4 combining a lack of notice and any opportunity to be heard with essentially what is an unlimited amount of time that they can put you
I'm a
in
little
for hearing.
confused. Isn't the burden higher at, not the 5-day hearing, the hearing that's otherwise provided for the statute within 30 days? And if you all are asking for adjournment some more time, how could you possibly be successful within a much shorter window of opportunity, based on a much lower standard?
We don't have any burden to prove. The burden is on the state.
No, I understand that.
So for example, if they bring a petition, they could bring a petition. We've had circumstances where they get the wrong name, or there's a factual, something is incorrect, or there's a misapplication of the law, or maybe the cyst violation never even actually happened, or maybe what the violation isn't, as a matter of law, legally sufficient to warrant civil confinement. We could make these arguments right away and maybe spare someone months of time in jail until they eventually get to make them whenever the state gets around to having.
If the state took 5 days, wouldn't you be able to do that rather quickly? If you're saying you could do that very quickly within the 5 days, you can't do it very quickly after the 5 days?
I'm sorry, we can have the hearing right away. When they bring the petition, After that initial 5-day detention period,
Yes.
we can go ahead and have a hearing, give us the opportunity.
With the psychiatric evaluation report, you think you could do that right away?
We
Or
don't
you
have
would
to get one.
You would forego that?
But you, in this case, you did ask for an adjournment to get a psychiatric report,
Well,
right?
for the ultimate determination, which, we're talking about the probable cause determination here, which is at issue. The probable cause finding results in a person being put into jail for pre-hearing confinement before we even get served with the petition. So the person's already in jail by the time we even really know what's going on. So after we get that petition, give us a very short turnaround time, we can go look
But
at it and make
the
the
examples
arguments.
you were giving before, some of the fact, it's the wrong name, it's this and that, those are things that you would quickly know right after the probable cause hearing that the judge missed, or it was just an error on the papers, and you could quickly, you don't have to seek the adjournment, you're then going to proceed. I
We're
mean,
not
very
always
quickly.
asking for adjournments.
But-
This is a fabrication that he's put forth.
I know, let me just finish, please. But the question I think some members of the bench are asking, including Judge Singas, is if indeed what you're going to do is try to show that the violation does not show that this is an individual who cannot control their impulses, that is to say, they need to be removed from CIST and now confined, that is not about some factual error, that's a legal conclusion after the judge looks at the submissions. You do need more time.
Well, for the ultimate determination, when we're looking at whether someone is going to be removed fully from CIST
Yes.
at the 30 days, that's why we asked for an adjournment. And in this case, they brought the petition on Christmas Eve. We had very difficult time finding an expert, and our attorneys, there was a lot of resources that were difficult at that time. We asked for one adjournment.
Yes.
And he was detained for 4 months and additional after that. And none of that was because of anything that he asked for. So the fact that we asked for one adjournment.
Are you saying you're unable to apply to the court, given those particular circumstances, for release?
I'm sorry?
You're unable, I just want to be clear, your understanding of the statute is under those particular circumstances, you couldn't apply to the court for release because you could see that, in your opinion, moving forward, there will be no hearing within 30 days.
Well, basically, what the initial probable cause determination would allow us to do is if they offer a very faulty petition, we could brush it away right away
Yes.
without having to go to the extra burdens of getting an expert and defending our position fully. It's a protection that's necessary to avoid basically just putting someone in jail on insufficient evidence that's plainly insufficient, and we can check those errors right away. That's why it's so important. So when he says there's no purpose of it because the burden's low, it's very important, because here, he made the argument that the alleged violation wasn't sufficient, and ultimately he won. But if he could have made that argument initially, maybe he could have stayed out of jail for 5 additional months. But he didn't get the
I
opportunity to
have
do
one more
that.
question, Chief. So if we agree with your adversary that the as-applied challenge regarding the duration is unpreserved, is the rest of your argument basically that there's no evidentiary support for the probable cause hearing?
Yes, we did.
Finding?
We made an argument beyond just the duration, that otherwise we could still have prevailed at a probable cause determination if one was afforded to him, but he was denied it.
And the 30-day, the failure to act within the 30 days, do you think that goes to the, on the face challenge, or is that an as-applied challenge?
It's both, because the fact is, the statute just suggests 30 days, but then immediately after abrogates any durational
But if
challenge.
some respondents have their hearing within 30 days, doesn't that defeat your argument as,
No,
on its face?
because you still couldn't bring a durational challenge. Maybe you think 26 days in confinement is too long on an ex parte basis. You can't bring that challenge. So the fact that you get no opportunity to be heard at all before being put into jail for a significant time, where you're going to lose any of your reintegration progress, you're probably going to lose your job, maybe your residence, your treatment's going to get interrupted. This is a significant deprivation to be done completely ex parte. So we absolutely need an opportunity to be heard. And the protections, they are illusory. The 30 days, it's not enforceable. When you ask what's the outer limit as written is eternity. They could keep you in forever. And that, on its face, is too long. And here, 5 months, 4 months beyond our adjournment, that's too long too, as applied.
Thank you, counsel.